Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Passing of risk. Risk means the liability to bear the loss in case of damage or loss. Risk is associated with the ownership. During loss of goods, the owner shall bear the loss of goods whether the payment or delivery has been effected or not. Risk passes with ownership and not with possession. The goods belong to the seller until the ownership in goods is transferred to the buyer. Where the ownership has not been transferred to the buyer, any loss of goods shall be borne by the seller even though the goods are in the possession of the buyer. Where the ownership has been transferred to the buyer, any loss of goods shall be borne by the buyer even though the goods are in possession of the seller. If the delivery of goods is delayed at the fault of any party, risk lies with the party who was at default. However, in certain cases, the risk may lie to other party as follows. Express exclusion. The risk of the owner may be modified by the parties by making an express provision in the contract. The parties may agree that in certain specified cases the goods shall be at risk of seller even though the ownership of goods has been passed to the buyer. Party in default, where delivery has been delayed because of the fault of either party or seller, the goods are at the risk of the party responsible for delay in delivery of goods, and he should bear all the losses arising due to delay in delivery of goods, even though the ownership of goods has not been passed to him. Example, X agrees to sell Y 150 liters of cold drinks in chilled condition packed in bottles, which are to be supplied by Y. Y is to come with bottles by 10 am to take delivery from X place. X kept the drink ready in chilled condition, but Y does not come with bottles to pack the drink in time. Consequently, drinks lying with X becomes inconsumable. Here, Y shall be liable for loss though the ownership of goods did not pass to Y, as the drink was not yet packed in bottles and was not in deliverable condition. Example, after cash sales, the buyer of the goods agrees to take the delivery after 2 days. On third day, the buyer wants to take the delivery, but the seller wrongfully refuses to deliver the goods. On fourth day, the whole stock of seller, including goods sold to the buyer, were destroyed by fire. Held, the seller has to bear the loss related to such goods, though the property in the goods passed to the buyer at the time of making cash sales. The buyer can claim the price paid by him. Risk imposed on a party by a custom. If there is a custom or usage imposing risk on any party, buyer or seller, such party shall be liable for any loss of goods even though he is not the owner of such goods. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.